recording in progress. Yes, we will get this recorded for those who may be missing this fantastic, wonderful session. But we always know that some of us will have alternative things to do, but we always take care of our seniors in every way possible. So for those of you who are new to us, we have been having this monthly meeting every Friday, but the good news is we are beginning to go physical. We are going to meet our eagles again. We are going to gather our eagles again. And to let you just a little bit advance notice here, this is what we are going to have. On 16 December, Friday, we are going to gather the eagles again. Let's gather and glorify the Lord to celebrate Christmas. So, early birds, this is the message for all of you. For next year, we will also continue to have physical. When the services at SMCC reopens in February, we will restart our gathering of our eagles. So you can look forward to more news later. Yes, we are so glad to have all of you here. We have 100 over attendance now. And this is a good time in which we think about our future. I'd like to introduce Pastor, lawyer, Au Yong Wai Nyan. Just now when Pastor Eddie was singing this song, I give you my heart, I give you my soul, my thoughts came to this pastor. Imagine yourself being a busy lawyer and God called you to give your life and your heart to him. And this is what happened to this Brother Wai Nyan. He has served the Life Gen. Those of you who know him, he gives a lot of fiery sermons that can touch us, encourage us, and lead us to draw closer to the Lord. So here we are, we have our Pastor Wai Nyan here to share with us his practical experience. He works as a lawyer and a lay pastor with us. And if we are thinking of a family who obeys the Lord, what we always hear, as for me and my family, we will serve the Lord. Here we have Pastor Wai Nyan and his wife, Melody, and the children. You can see them in church. You can see them doing lots of wonderful things. So today, we are so blessed to have him here with us to share, do we really need a will? And in this session, please, while you listen to him, if you have any questions, please just type it in the chat. We will follow up with a Q&A session. So let's welcome Pastor Au Yong Wai Nyan. Wai Nyan, can you,
Thank you, Paul. Thank you, everybody. Appreciate the time to just share with you. I just noticed that as I'm doing this, Golden Eagles has milked me on both a pastor and a lawyer, and making sure you get the best of what God has put in my life in terms of my calling. I know that oftentimes as a lay pastor as well as a practicing lawyer, you take off and take on hats, right? So you switch off pastor mode, turn on lawyer mode, switch off lawyer mode, turn on pastor mode. And one of the things that I try to do with my life is, if this is what God has called me to do, then how do I integrate every single part of my life together? That's the question that I ask myself every time I do my work, even not just lawyer and pastor, but as Paul mentioned, a father as well, a husband, and just how do I integrate all of these things that God has placed in my hands to do and in my life to live out. And so doing this today is part and parcel of that, I believe. And so because it is Golden Eagles, and because the last time, and I'll just telling this to Pastor Eddie and Brother Paul just now. The last time I did this, I remember it was in Golden Eagles. I remember Pastor Stephen was there, Pastor Eddie was there, and it was in if I remember correctly, 2014. And so it's been, and then when Pastor Stephen messaged me and said, "Hey, why don't you do this with Golden Eagles?" I had flashbacks of the time that I did it with Golden Eagles many years back. 8 years on, 8 years as a lawyer, subsequently, 8 years in serving God later. Many things have happened. Pastor Eddie is now Pastor Eddie. I still haven't gotten quite used to people calling me pastor, so feel free to just call me Brother Wai Nyan or just call me Wai Nyan. Don't worry about it. It's still something that I'm trying to, I don't know if I really want to get used to it, because I still have this part of my life where people don't see me as a pastor. They see me as a lawyer. They see me as someone who represents them in court, or someone who advises them as a client. But that's the journey of my life so far. So what I'm going to do today is share with you the question that was posed to me to talk about this was, do we really need a will? And because, like I said, I want to put the lawyer and the pastor hat together as much as I can, I will share with you some of the things that I have experienced in terms of practice, in terms of, let's say, as someone with legal experience advising you on some of these questions, but also to just ask ourselves, what does God say about this? Just some thoughts that I had in my mind as I was preparing this, and some of the things that I feel God wants to tell us, which may not necessarily be just to answer the question of yes, I should do a will, or no, I shouldn't do a will, but what is God's heart for each one of us? And it, in fact, very interestingly, is reflected in this particular discourse about wills. So let me get right on to it. I'm going to take off my pastor hat for a while and put on the lawyer one a bit, and just run through some of the things that we talk about. Now, I also understand this because I'm talking to Golden Eagles. I'm not talking to Life Gen people who probably have never even heard of a will before in their lives. But I'm talking to people from Golden Eagles, and over the years, I've seen a lot of people share stuff on WhatsApp, send WhatsApp viral messages, things like, for example, make sure you have a will, or make sure that you do certain things with your EPF money so that the government of Malaysia doesn't get it, doesn't take it away from you, or doesn't take it away from your family, things like that. So if you do have questions like, is this true? Because my friend forwarded as received, but don't know whether correct or not, then call this number and that kind of thing. If there are questions that you have, feel free to ask in the chat, and then I believe Pastor Eddie and the team, the Golden Eagles team, will help to kind of moderate it or collate those questions so that we can try and answer as many questions as we can, and as well as clear some doubts that you may have. And so we're trying to do that as much as we can today as well. I'm going to share screen, so just give me a quick moment to just set that up. There we go. Do we really need a will? As a lawyer advising people on questions like these, I often say yes. That's just generally the big answer. But there's a lot more to it. There's obviously a lot more questions to be asked about it. There's a lot more questions to say, well, actually, what do you mean by this? What does that mean to say, yes, I really need a will, or you need to do a will? And so that's what we're going to explore today. But I thought I'd start off with this little question at the bottom. Fill in the blanks. Where there's a will, there's a ... And so we know that phrase, right? Where there's a will, there's a way. But we lawyers think of it very differently. We often joke, where there's a will, there's a lawsuit. And that's what we essentially want to avoid. And the reason why we do talks or share with people about wills is this: we see all this in court, right? Whether it's Cantonese courtroom drama, or the one biggest memory of a scene in the show that I've seen before is one of the old Superman, not Christopher Reeve's time. This is Brandon Routh's time. So one of these old movies where the starting of the show is Lex Luthor forging the signature or thumbprint, if I remember correctly, of a person who was about to die, so that he would be able to inherit this entire sick person's estate. And I always remember that in my mind because he he locked himself in the room next to the guy that is on his deathbed, and then forged the will and made it look like he was executing a will, and then getting all of the estate for himself. And so oftentimes the joke amongst lawyers is, where there is a will, it is never the end of the question. There's always a lawsuit on the way. I have, in my experience, dealt with lawsuits dealing with wills. They're not nice. They're obviously not very, lawsuits in general are not very fun for the clients when they go through these situations. And so what we want to look at today is, when we do wills, how do we make sure that it really kind of exhibits what the person who's making the will really wants, and avoid as much as we can any form of dispute as to what the will looks like. So where there's a will, there is hopefully no lawsuit, and that's what we want to see take place. Now, what exactly is a will? A will is under Malaysian law is a written document. First of all, now there are arguments that allow for you to say, make an audio message and say, or a video, right? And say, maybe because you cannot write it down or anything like that, and say, I give this to so and so, I give this to so and so. But for as long as we can, it is as best possible a written document, because a written document signed and witnessed and written down does not change, unless a new written document covers it. And so a written document is what a will should always be a written document. And the will basically is instructions on how to deal with a person's property once he or she passes away. I'm going to use the word estate. There are many different definitions for the word estate. Estate could mean land, for example. But in the case of what I'm going to talk about today, when I refer to estate, I refer to the assets and the liabilities. So the things that you have, whether it's land or bank accounts and things like that, the things that you have in the life or in the possession of a person who has just passed away, the estate. All right. So it would say, for example, if I pass away, that would be the estate of Au Yong Wai Nyan. All right. So that's how I'm using the phrase estate. So a will is a written document, and basically what it does is provides instructions on how to deal with my assets, deal with the assets of the estate once the person has passed away. Who are the important people in the will? The important people in the will is firstly the testator. Legal terms, but basically testator means the person who's making the will. So if I've done a will, which I have, so as the will in my will, I am the testator. If you do a will, you become the testator. All right. The executor is the person that you have appointed in order to carry out the instructions in the will. So the will has instructions. The will also appoints somebody to do these instructions, to execute these instructions. All right. So that's the executor. And then the last one is a beneficiary. So the beneficiary is, who do I want to give these assets to? Who do I want to give these properties and assets that I have in the estate to? All right. Now, these are the three important types of people in the will. And these are the things that you will need to think about when you are doing a will. The next one is this. If I pass away with a will, what happens then? All right. Now, the reason why I'm going to show this to you and explain this to you in short note form first is because then I will also compare this if you pass away without a will. And then when you see the difference, I hope you'll be able to see what the impact will look like as far as your own estate is concerned. So if I pass away with a will, the term that we use there is testate. It's again a legal term, but it basically means that there was a will, this estate has a will, so this person died testate. If this person has died testate, then the executor will go to court and apply for what is known as a grant of probate. All right. A grant of probate is essentially a court order that identifies the person who has passed away, identifies who the executor is, and gives the executor the authority to deal with all the assets of this particular person's estate. All right. So if I pass away and let's say I name my wife as my executor, then she will apply in court for a grant of probate, and the grant of probate, an actual written order of the court will give my wife the authority to deal with all of the assets and liabilities that are in my name. All right. So if there's a house in my name, she has to deal with it. If there's a bank account in my name, she deals with it. If there's a loan in my name, a liability, she will also then be able have the authority to deal with those liabilities with the monies in the assets, with the monies in the estate. So those are things that will take place when if I pass away with a will. All right, you get a grant of probate, the court will appoint the executor that I've named in the will, and then the estate will be distributed according to the will. I pause here now to just maybe give you a big picture of what has happened, what happens in terms of a will. For all of us who are still alive, right? When we decide to make a will, we produce a written document giving instructions, appointing who the executor is, identifying who our beneficiaries are. And when we have done that, we put it into a document called the will, and then we leave it as it is. Life goes on as normal. But if we do pass away, if and when we do pass away, the person who I named as the executor in the will, then goes to court, applies for a grant of probate, and with that grant of probate, then deals with the assets that I have according to the terms and the instructions that I've put in the will. And so you essentially have a process of coming up with instructions all the way to the execution of those instructions at the point when I pass away. Let me just stop here. I know, Rosalind, you've raised your hands. What we'll do, I believe if that is a question, maybe could you just type it in the chat if possible, and then Pastor Eddie and the team will look into it as well. And so let me just continue first, and then we'll look at the questions later on. Yeah, thanks, Rosalind. And so that's essentially what happens if I have a will. Now, what happens if I don't have a will? And that's the other question. Well, let me just move on there first. What if I pass away without a will? If I pass away without a will, that means I do not have my own instructions as to how my assets are to be dealt with, how they're to be distributed. If I don't have instructions, then essentially no one knows where my house is, who my house is going to be given to, where my bank account monies are going to be sent to, things like that. And so if we don't know what the instructions or what the intention of what my intentions were as far as my estate is concerned, then the term there is intestate. That means no will. And if it is intestate, the court will then have to give a grant of letters of administration. Now, that gets a bit tricky, because what happens then is this: if I don't have a will, the law identifies specific people who will become automatic beneficiaries. For the most part, it's not really an issue, because the automatic beneficiaries are usually the spouse, the parents of the deceased, and the children of the deceased, if any. I'll give you a little table later on to show you how that works. But my point is this: if a person dies intestate, the people who are named as beneficiaries under the law, not under the will, under the law, will then apply to court for a grant of letters of administration. All right, when they apply to court for a grant of letters of administration, the court will then identify, okay, you're a beneficiary, I will give you the letters of administration, I will appoint you as an administrator. When you are appointed as an administrator, not an executor, when you appoint you as an administrator, you now take all this, the person's assets, and then distribute it according to the law. So the law actually has a set list of people who are beneficiaries in the event that there is no will. All right, and so you follow what the law provides, and I will show that to you in a bit. The other thing that you must take note of, which is different from a will or someone who passes away with a will, is that if you are appointed an administrator, and if the assets of the deceased are more than 50,000 in value, then the administrator must also provide to the court guarantors to guarantee that the administrator will do the job well. All right, and so guarantors to guarantee that the administrator will do the job correctly, will do the job, will do the distribution of the assets fairly and properly to all the beneficiaries. And so these are things that the court will consider before appointing an administrator in this sense. Now, if I pass away without a will, what does that mean as far as my beneficiaries are concerned? Don't worry, you don't have to take photo of this. I know some of you are like, put up the handphone and take this. I will send this over to Pastor Eddie or Brother Paul or Jane, and then say, look, you can have this, have a look at it now. But basically, it is this. There are very many permutations that the law covers if somebody does not write a will and pass away. Right? But essentially, the focus will be given to first the spouse, the issue or the children, and the parents of the deceased person. So put it this way, if I pass away without a will and I leave my wife, I don't have children, and my parents have said they've passed on, then very easy, the result is my wife gets everything, right? But if let's say I pass away, my wife has passed on, so let's say I'm a widower, I still have children and my parents have passed on, then very simple, my children get the assets of the estate. If I pass away and I'm not married, I've got no kids, and only my parents have survived me, then my parents get the assets. And then after that, it gets a bit more complicated. If I pass away, so I'm at line 4 there, if I pass away and my wife and my children survive me and my parents don't, then my wife gets 1/3, my children get 2/3. And the list goes on. Essentially, they're looking at, first of all, spouse, children, and parents. All right. And so the last one, if my spouse, my children, and my parents survive me, then it becomes 1/4, 1/4, and 1/2. All right. Now, this is what the law provides. Big question. What happens if I pass away without unmarried, no kids, and my parents have also passed on? Then we look at this. If there is no spouse, no children, no parents, the estate will be distributed in equal shares to the following people who are entitled in the following priority. So there's a priority list there. First of all, my siblings. All right. So if I pass on without wife, no kids, and my parents have passed on, all my brothers will get the share of my estate equally. In this case, my brothers, because I've got 2 younger brothers, and so they are my siblings, they get the share. If they are not there, so again, in order of priority. So if I don't have brothers, let's say I'm the only child, then my grandparents get it. All right. If my grandparents have passed on, then my uncles and aunts. And then if I don't have any uncles and aunts, then my great-grandparents or my great-grand-uncles and aunties. And then all of you are looking at the last one, Government of Malaysia. All right, the Government of Malaysia takes your assets at the end of the day if you literally have no surviving next of kin. And so in that kind of context, then yes. Now, maybe you might be asking me, where's the cousins? Maybe I give to my cousins lah, but cousins are not listed under the law. All right, the cousins are not listed under the law. So if you do not have a will, your cousins won't get anything. And that's maybe something to think about, right? Again, what the law tries to cover is as many permutations as possible and as wide as your family is as possible. And only when you have literally no surviving next of kin, then the government of Malaysia takes it. But this is very last resort. The government of Malaysia is the very last resort. So I would usually suggest to you, if you end up not deciding not to do a will, don't worry. Your surviving next of kin will get something, unless you really have no other family left. But if you have friends that you really want to bless, or you want to see that your assets go to some good cause, then my suggestion to you, do a will, because that tells the world, this is your intention, this is what I want to do with my assets. So I go back to that question that I skipped just now. Why is a will important? A will is important firstly because you then have control over how you want your estate dealt with. And that control is important because firstly, it leads to lesser, if not totally eliminates confusion. It's the ability to say, look, these are the things that I have in my hand. This is how I want it to be addressed or distributed or dealt with. In fact, the courts are very clear on this. Whenever a will goes to court for whether someone is disputing about it, one of the biggest things that the court will ask is this: what was the testator's intention? So if I made a will and the will then gets disputed in court, basically they look at the term in the will and go, oh, someone says this is what it means, another person says, oh, this is what it means, and the interpretation is being disputed. The court's primary question is, what was Wai Nyan's intention? And they will try and identify that intention and then give effect to that intention as best as they can. The only thing is this: the person who made the will isn't alive anymore. And so they will have to look at the words, they would have to look at the context in order to identify this is what this person intended. But that is the question the court wants to get at. What is the testator's intention? So you have control over how you want those assets dealt with. If I want to give it to a charitable cause, if I want to give it to this particular person, or if I want a share to be given to my children in a particular way, or if I want to say, look, if my children are still minor and they haven't finished their education, I want to make sure that my assets are dealt with in such a way that it provides for their education rather than I just give it straight to them. Those kind of things, a will enables you to have a say over how you want your estate dealt with. The second one is this: it saves the family a lot of hassle. Because it's very clear what your intentions are, it reduces fighting between family members, it reduces confusion, and it saves a lot of time and money. I'll tell you this: when a person comes to me and says, my father or my mother passed away without a will, as opposed to somebody who says, my father or mother passes away with a will, the costs involved in getting a grant of probate or a grant of letters of administration differ, because the amount of work, it differs as well. And it saves a client time and money in whenever the deceased person had a will, because it is a lot easier to inform the court, this is the executor, and the executor now has authority to then deal with the assets of the estate. So it saves time and money as well. But the principle, and this is what I want to refer to in the third one, the principle of setting your house in order. The Bible doesn't say very much about it, but there are some people. Isaiah is a big example of that. When he spoke to, I think it was King Hezekiah, and he said, "Look, King Hezekiah, as far as God is concerned, you will be passing away soon. So set your house in order." And it was a principle that they followed, whether you're a king or not a king. The Jews did this when they know that they were going to pass away. They wanted to set their house in order. That does not just mean do a will. It means obviously reconciliation with family members, basically setting aside resentment, dealing with unforgiveness or whatever issues that have not been dealt with in the family, and then saying, I'm going to go, I want to clear all these issues out. But part of that is also to identify, in our case today, identifying how I want my assets to be dealt with. Now, I'll tell you, back then in Israel's times, they didn't have wills to make. The law did not provide an opportunity for them to make wills. And I'll give you some examples of that later on. But today, in our time and age, when this is what God has placed in our hands and blessed us with, the right and the opportunity to say how we want these assets dealt with when we pass away is given to us by law. And it gives us an opportunity to, with God's wisdom, know what to do with these assets as well. And that's why I think setting your house in order is very important in terms of doing a will. Because what you're essentially saying, and this is what I remember my father told me when he was working out his will, he said essentially this: look, all that I have in my hands are what God has given me. And when I know that this is what God has given me, I want to also know for sure and set out for sure in my will what God wants these assets, how God wants these assets to be dealt with. I'm not giving you everything. That's why I told me, I'm not giving you everything. Whatever God has given me has to be used for God's purpose. And so there are funds that go to missions, there are funds that go to whatever other purpose that God has placed in his heart. And if you don't do a will, it does not get there. And so that's why it's important to do a will. Because as you pray and as you see God placing certain things in your heart and giving you these assets or these gifts that he's given you, and these assets is in your hands to use for God's purposes, then by all means, let your will be an expression of your intention to follow God's will, follow God's heart, and it applies even after you pass away. Legacy is an important thing that we talk about in scripture as well. And when we talk about legacy, it doesn't just talk about how you spend your time and energy, which is important, but even how you look at your assets as you after you've passed on. And so doing a will lets people know what your intention is, especially when it is to follow God and what he wants to do. And so that's why I believe a will is very important. And I would definitely suggest that all of you do wills. Let me move on. A bit more practical. How do I write a will? Just about 2 weeks ago, I spoke with a family, very, very loving family. I think, it's just very loving family. And the patriarch of the family had passed on. And as I said with the family, and we were working out the application to court for the grant, we also discussed things about making wills and what does it look like and how it's to be done. And so I thought I'd share with you for you to begin to start thinking about, especially if you've not done wills, or if you want to revisit your will or review it and see this is what my intentions are, to think about these things when you talk about how do I write a will. And so the first thing that we want you to consider is to identify your assets. Identifying your assets is very important because for two reasons. First of all, if you have specific assets that you want to give to specific people, identifying your assets is obviously the first thing you've got to do. I remember very early on in my practice, we had a client who had a lot of jewelry collected over the years. And she had in her mind the intention of wanting to give specific people specific pieces of jewelry. And so she would tell us, okay, this particular necklace I want to give to my daughter. This particular necklace I want to give to my daughter-in-law. This particular necklace I want to give to my niece, and so on and so forth. So I think if I remember correctly, about 10 or 11 pieces of jewelry that she had specifically identified for specific people. And so what we had to do was take photo of the necklace and then say, okay, this one goes to so-and-so. Put IC number there, right? This one goes to so-and-so. This one goes to so-and-so. And so that was one of the important reasons why you identify assets. But the other reason also is this. There will probably be most of us, if not many of us, who would say, actually, I don't have that kind of intention. I just want to give all my assets to my kids. Everything I give to my kids. So just do a general will, just say all my assets I give to my children, which is fine. That's okay as well. But what's important is this. Your executor, whoever that person is, needs to be able to know where your assets are and how to get them and how to identify them wherever they are at. So many of us would have perhaps some property. Maybe some of us got cars, motorbikes, jet plane. Maybe Jolo gave you his yacht. Bank accounts very common. So fixed deposit, savings, joint accounts, investments, bursa account with bursa or mutual funds. I remember someone saying, I invested in bird's nest. Can I put it inside my will? I said, can, of course, but you have to tell me how to identify the bird's nest that you invested in, and what kind of account number you have, or how does your returns come. Personal items, some of them have very high sentimental value. Jewelry, vinyl records. All right, we've heard of this before. I've got a whole set of vinyl records. Nobody plays vinyl records. Most people don't play vinyl records nowadays, but I have them, and they have very high sentimental value for me. I want to give it to specific people who I believe will actually enjoy that gift or will benefit from that gift. Or even sentimental photographs. I've also come across people who have asked me about antiques. So, I'm an antique collector. I like this really big, chair from whatever dynasty from years ago. And I collect all these things. I want to identify them. I want to give them. So these are all your assets. And identifying your assets is important. So when identifying your assets, your properties, be specific, so that either you want to give them specifically to different people, or you want to help your executor identify them. Executors, whether how young or how old they are, may not necessarily know if you invested in Bitcoin. And if you have invested in Bitcoin, and how do I even get this virtual cash out of somewhere? These things need to be identified specifically so that the executor knows exactly what to do. And that helps the executor when dealing with the assets. And so these are things to think about when you first of all identify your assets. The second one is this: identify your executor. Now, who should the executor be? It can be a family member, it can be a friend, it can even be a beneficiary. So, for example, I've heard this question before. I appoint my wife as a beneficiary. Can I appoint her as an executor as well? By all means, you can. There is no question of conflict of interest. The executor basically is the same person as the beneficiary, but that's not an issue as far as a beneficiary and executor is concerned. So you can appoint a family member, you can appoint a friend, you can appoint a beneficiary. You can also appoint a trust company. You may have heard of some of these before. Certain banks have, like I remember HSBC used to have one as well, for private investment funds, and so they also offer the service of being trustees or executors. Rockwell's, I believe, does one as well. A few other companies do that. So trust companies, but they can be costly. Some of us as lawyers have been asked about the public trustee, Amanah Raya. They can also do it, but because you have appointed a company to do so, they have rates of charges that you would have to agree to if you want to appoint them as a trustee or executor of your will. But remember that whatever charge you agree to, you are not paying it. It's the estate that will eventually pay it, because the trust company only kicks in after you've passed on. And so it will be the estate's money that will be going to the company to cover the charges for administering or for executing the will. You can appoint as many people. So I can appoint my wife, I can appoint Pastor Eddie, I can appoint Pastor Stephen, I can appoint Brother Paul, I can appoint 5 or 6 different people. But at any one time, only 4 executors maximum allowed. This is when the court gives its grant of probate. Even though there are 6 people in the list, the court can only give it to a maximum of 4. That's what the law provides. But here are some of the tips that we want to just share with you. First criteria must be trustworthy. All right, this is the reason why we suggest people do wills, because if you do a will, you have the opportunity of identifying someone you can trust in order to become the executor. In certain cases, some people would rather prefer their sibling to become the executor, not because the rest of the family is not trustworthy, but because the sibling may have the expertise to become an executor. I know, for example, that where siblings are, let's say, like in my case, for example, if my brother is an accountant and he knows how to do the calculations and the math and all of that, then perhaps it is a better option for him to be an executor. And sometimes these are considerations that people take into account as well. And so find someone who is trustworthy, find someone who is willing to be an executor. So someone who knows, okay, if I appoint you as an executor, are you okay with it or not? Rather than point someone who really doesn't want to be an executor at all, and the moment you pass on, he relinquishes his role, and then you end up having to find somebody else, or the estate has to find somebody else to become an administrator because the executor relinquished his job. And the last one, and with all due respect to Golden Eagles, usually someone younger. The reason for that is this, because we want to make sure that the person survives you in order to become the executor. And so that's the reason why we usually say get somebody younger. So these are some of the tips, but it's important to identify your executor. Oftentimes when people come and tell me, I want so-and-so to be my executor, I make sure you give me a copy of the IC and an address, so that we're able to identify specifically who this executor is. And then when the person has passed on, we know this executor, we can approach this person and say, You have been appointed as an executor to take up this person's will. Can you now take it up? Are you willing to take it up now and then proceed with the grant of probate? So step 1 was identify your assets. Step 2, identify your executor. Step 3, identify your beneficiaries. So oftentimes the beneficiaries are family members. That's partly our culture. That's also partly how the law looks at it as well. The default is usually your family members, but it can be anybody else. It can be friends, it can be other relatives, it can be other organizations. I've done cases where people give them to schools to fund a library or to build a new hall with charity organizations. I've done one where somebody wanted to give the Generasi Gemilang. These are things that as long as it's an identifiable legal person able to take on this gift once you've passed on, they can be a beneficiary. But however it is, it must be specifically named. It must be specifically identified. We've had situations where the scenario goes like this. I want to give to my children, and then they start thinking of alternatives, like what happens if my children pass away or do not survive me? Or what happens if, let's say, I want to give to my wife and we happen to be on the plane trip together and then my wife does not survive me, right? Then alternative beneficiaries are also allowed in the will. So they could go say, if my children don't survive me, I pass on to my grandchildren. Or if my children are not married and they don't have grandchildren yet, then I pass it on to an alternative beneficiary, let's say my siblings or some charity organization, things like that. So alternative beneficiaries are also allowed. But first tip, be specific. So identify specifically who your beneficiaries are. Provide an option if they pass away before you or before they can obtain your property. And if the beneficiaries are under 18. So let's say for most of you, especially if you're grandparents and your grandchildren have not reached the age of majority or 18 yet, provide options on, you have the opportunity to provide options on how to give them the property for investment or for education, or even to stagger the distribution. So I know that there are parents who are very concerned about giving their kids or letting the executor transfer the assets to their kids the moment they turn 18. So the moment you turn 18, you are you not just can you vote nowadays, but you get to own property, you get to own assets because you've reached the age of majority. But sometimes you look at the 18-year-old and go, I don't think this person is mature enough to handle this kind of properties. And so we give the executor the right to invest in some of these properties. So you have these monies in the bank accounts. I want you to invest them in a very safe investment so that there will be returns. And then, although my child has turned 18 already, you only distribute to my child on a staggered basis. Let's say an amount of 5,000 every year, for example, or that number may increase the moment you've started working, or once you've gotten married, fine, I give you everything. Things like that. So the will gives you the opportunity of making sure that your intentions are meted out and explained and expressed. So that gives you the opportunity. If you did not have a will, then automatically the moment the person turns 18, he has a right to claim the entire set of assets or shares for himself, and that would be his already. If he wants to go to court and fight it out, technically he can. And so having a will allows you to consider these options and then make a decision as to how you want these assets to be distributed. Yeah. So step 1, identify your assets. Step 2, identify your executor. And then step 3, identify your beneficiaries. And then step 4, just the formalities. And this is the one that's interesting because people want to know what really amounts to a will. Like, do I need to get it stamped? Do I need to register it in a particular place? The actual answer is no. Anytime you've expressed your intention in a particular way and you've met these formalities, it becomes a will and it becomes effective immediately to kick in when you've passed on. All right. So it must have at least 2 witnesses. Here's the little caveat that we have as far as witnesses are concerned. At least 2, meaning that you can have as many. All right. You can have 10 people as witnesses, but none of the witnesses can be a beneficiary or a spouse of a beneficiary. So for example, if I want to give it to my children, let's say they've grown up and they're married, I give it to my children and my son-in-law signs as a witness to the will, then whatever gift I meant for my daughter will not be valid. So if I say I give my daughter my car, and then my son-in-law signs as a witness to the will, the gift of the car to my daughter will not be valid. The rest of the gifts in the will may still be valid, but that particular gift to my daughter will not be valid because her husband was a witness in my will. So usually what takes place is if you do a will and you want to identify or get people to witness it, get someone who is close to you, but someone not related to the gifts that you are giving in your will. That's usually the safest way to get around it. If as lawyers we do it, most of the time the lawyers are the ones who end up signing as witnesses to the will, because we are far removed enough from the gifts in the will. So as long as you make sure that that's the case, then you sign the will, put your thumbprint, and the moment you do so, and the moment the witnesses have signed it, it is a will. You can frame it, you can laminate it, you can keep it in a safe, and the moment you pass on, someone takes it out, and that becomes the will that will be an expression of your intention, which means a few things. The first tip is to update your will regularly. Because you have not yet passed on, things happen. You may have sold the house that you've identified in your will. You may have changed to a different car. You may have moved bank accounts and moved funds here and there. You may have invested into newer things that you're investing in. Things happen in your life, and God has given you different treasures or different things that you can hold on to. And so what is important is to make sure that you update your will regularly to look again, who are the executors? What are my assets? Who are my beneficiaries? Is God placing something else in my heart to give to? Perhaps the executor may be a bit too old, or he has fallen sick. Maybe I should appoint somebody else, things like that. So updating your will regularly is important. And when you update your will regularly, every time you update your will, the moment you follow the same formalities, you sign, witnesses sign, on that time it's done, it becomes the latest will, and the previous will becomes null and void. Basically, it's not effective anymore. And so we're always looking for what is the latest will that is made. I remember doing a case once where the client passed away in 2011, and in 2011 he's a fairly well-to-do man, fairly rich man, elderly guy. And when he passed away, we wanted to look for his will, and we realized his will was the last will he had was in 1979. And someone managed to actually locate the will, take it out, and let us have a look at it. It was very properly kept. It was sealed. And when they opened it, it was a 1979 will. And what was really interesting was this. Since 1979, we heard that the person who had passed away had strained relationships later on with his children, or at least one or two of his children. And it was always assumed that because of the strained relationships, he would have revised his will in order to make sure that the people who he was closer to would get a bit more of the assets. But it was found out that he did not actually revise his will. And the rest of the children, interestingly, felt that their father had actually been very magnanimous with his gifts, because although he could have actually changed the will to deal with the strained relationship, he did not. And so all the children got what was initially given to them in his earlier will when the relationships were still fine. So different things take place in different people's lives, different considerations. My suggestion to you is when you have done a will, is to regularly review it and update it once a year, once in 2 years, to do so, just so that the will is up to date with what is going on in your life and what God has placed in your heart to do. So update your will regularly. And second tip is, once you've done a will, attach a list of assets and liabilities. This is just to help your executor. The list of assets and liabilities do not form part of the will, but attaching it together with it helps the executor, because once he's got the will, he knows this is where the assets are, this is what I'm going to look for, this is who I've got to write letters to. Let's say I need to speak to this bank, or I need to speak to this insurance company, or to Bursa, to identify these assets and then obtain these assets. And so that helps your executor a lot, especially if your executor is someone who does not see you on a day-to-day basis, or does not know what your life revolves around. And that would really be of good help to the executor. So that's step 4, formalities. I just want to, before we look into some questions, just share with you a bit more. So I'm going to take off the lawyer hat, put on the pastor hat a bit, and just some thoughts that crossed my mind as I was thinking about this. And okay, well, before I do that, big question: do I need a lawyer? I get this all the time. Because they get the advice from the lawyer, which I usually give free. But then the question is, then do I really need a lawyer to write this will? You don't. You don't need a lawyer. There are many people who do this as a service for a fee. Lawyers do, will writing companies do, insurance agents do. I know of individuals who have wide experience in helping people write wills. And so they do that as a service as well. But you can also write a will yourself. I know people who've taken templates from the internet, worked it out, and then did it themselves. The only thing basically is this: if you want your will to be valid and effective, you want to make sure that it identifies people properly, it identifies gifts properly, identifies the beneficiaries properly, it meets all the formalities. It's very important, I would suggest, to make sure that someone who has professional experience at least go over it with you, and gives you some advice as to how to proceed with it. I usually suggest lawyers do it, because lawyers having legal experience, but also we have legal professional liability. We are liable for negligence. And so we have professional indemnity insurance to cover us. And so if there is anything that goes wrong subsequently, then we are liable for it. And so we basically put our money, we put our foot where our mouth is. We put our advice, our professional advice, at risk. So we make sure that we do our best in what we do. But yes, you don't need, technically you don't need a lawyer, you can do it yourself. Let me move on to what does the Bible say about writing a will. This is what I found really interesting. The Bible says nothing, as far as I know, about writing a will. I know it talks about setting your house in order, but like I said just now, setting a house in order dealt a lot more to do with relationships than about writing wills. Also because inheritance law in Israel was already fixed by God. So there are some examples of that. Very interesting story of Zelophehad. Zelophehad was a guy who had 5 daughters and no sons. And it was a patriarchal inheritance law that under the Mosaic law. And so if you had no sons, then it will go to other people, usually the father's siblings, the father's brothers. And Zelophehad's daughters, when Zelophehad passed away, the daughters came to Moses and said, look, this is the law, but my father had no sons. Because he had no sons, technically now as children, as daughters of Zelophehad, we have nothing. Can we take our father's property? Can we take our father's assets? And Moses sought the Lord, and the Lord said, yes, they can. There are some criteria to it. There are some restrictions to it in order to keep it within the Manasseh clan. But essentially, the idea was yes. Point being this, inheritance law was already fixed by God. It wasn't a case of giving you the ability to decide how you want to deal with your assets. The other example of that was the double portion of the firstborn. So if I have 2 sons, for example, the firstborn gets a double portion compared to the second son. You will notice that in the story of the prodigal son as well. But the double portion essentially is a priority in terms of how distribution is made, that was set by law for the firstborn son. And so he gets a double portion of the inheritance. But today, when we look at what God says about inheritance, this is what I found really interesting. The Bible talks about as an inheritance in God as a reward for following Jesus. And as I just kind of searched out keywords, right, like say wills, nothing, inheritance, heirs. And in this famous passage in the Bible where we are co-heirs with Christ, right? Why do we use the word heir? Why do we use the word inheritance? Oftentimes we look at inheritance as something I get when somebody passes on. So if my father passes away, then I get an inheritance. If I pass away, my children get an inheritance. But God does not actually pass away. And if God does not pass away, what do we mean when we talk about heirs and inheritance? And the interesting thing that the Bible tells us about heirs and inheritance is that it is a right. It is a right that you have because you follow Jesus, because you've believed in Jesus. You have this right to be an heir and you inherit what God has for you. Now, because God does not pass away, when do we then get this inheritance? The inheritance is actually now. And that's interesting because you remember the story of the prodigal son? The prodigal son told his father, give me my share of the estate now. Now, and that's a very rude thing to say to a father. It's basically saying, I treat you as dead to me. I want your share of the estate. And so give me my share of the estate now. But in God, because God does not pass away, our right and our inheritance in God is now. And our inheritance with him is righteousness, is peace, is joy. The Beatitudes, blessed are the meek, for they will inherit the earth. The things that God has given to us because Jesus Christ has already made a way for us to be in relationship with him, allows us to partake and become a part of all that God has for us in God's riches. I remember my father telling me, we used to sing and declare that our Father has a cattle on 1,000 hills. And my father used to tell me he also owns the hills. He's literally got everything. And everything in Christ is ours as well. And we don't have to wait for somebody to pass away because that's never going to happen as far as God is concerned. The inheritance is for us. It's the now. And Ephesians 1:13-14 basically says this, in him, you also, and this is what Paul was telling the Ephesians, when you heard the word of truth, the gospel of your salvation, and you believed in him, you were sealed with the promised Holy Spirit, who is the guarantee of our inheritance until we acquire full possession of it to the praise of his glory. And this is what Paul was looking at. He says, when we come to the end of days and we see Christ and we are with him in heaven, our entire lives is full of the riches of God. The promised Holy Spirit is the guarantee of that in our lives. And so I want to encourage you, besides looking at what you have in your hands and what you want to give to people, remember that all that we have now is what God has given us because we know Jesus, because we've believed on him, because we have the Holy Spirit as a guarantee of what he has given us. And he has blessed us with so much. And out of what he's given us, as a way of saying, God, this is yours, this is for you and your purposes, this is me wanting to bless because I've been blessed, show me how I should get these assets distributed when I pass on, in order to leave a legacy that says, these things that God has blessed me with, I want to bless the world with. We can't take any of these to heaven. I'm sure you've heard of jokes where guys bring gold bars and then St. Peter says, hey, tar for our roads have arrived. We can't take any of this to heaven and say this is ours. But what we can do with what we have, what God has given us on this earth, is to bless, is to fulfill the purposes of God for the next generation and the generations to come. And that's the legacy we want to leave behind. I stop here. I know that the chat window has been buzzing. So I open some time for some Q&A. You can ask me to put on the lawyer hat or the pastor hat, whichever it is. Just want to interact with you guys and go ahead. So go ahead, Pastor Eddie and the team.
Thank you, Pastor Wai Nyan. It's a very interesting and yes, you are right. So many questions coming in, and we're going to before I get to Auntie Sue and Juliana ask any questions. There's one lady wrote here, Pastor Wai Nyan. Can I appoint my daughter-in-law as executor? She must be a good mother-in-law,
Excellent. The joke I have in my family is I think my mom loves my wife more than she loves me. The reason for that is I get information from my wife that I would assume my mom would have told me personally, like directly. And it was, how come she tells you? And so yeah, so that's so if yes, you can quick answer to that is you can appoint your daughter-in-law as an executor, and go ahead with that. Yeah.
Wonderful, wonderful. Okay, Juliana, any questions? I saw a lot of questions. Please shoot.
Oh, it's a long, long list. I will start with the earliest one that was posted by Janet Lim. What happens if there is a joint executor?
Okay. So yeah.
Haven't finished the question because there was a lot of noise at the background. Could somebody just mute? Okay, the question goes like that. Janet asks, what happens if there's a joint executors, two and one dies before the testator?
First of all, I would say the testator made a very wise decision to appoint two executors because he took into account possibly the possibility that of the two, one might not survive him. But what happens? So if there are joint executors and he has named two, for example, if let's say I name my brother and my wife as executors, and let's say my wife passes on because we were on the same trip together, my brother automatically, or the remaining executor automatically becomes the sole executor in the for the estate. And so then he gets the right to apply to court for a grant of probate, and then he is the one who will be the sole decider or signatory to do whatever needs to be done to follow the will. And so that's the case. If, for example, the testator passes on and there are two people, so you have got joint executors, none of them have passed away before the testator, then the joint executors themselves can work it out together, or they may even decide, why not just one person do it because the other person may be overseas. So again, things change, right? People's lives change, the directions change. Somebody might have migrated, the person remaining in Malaysia may be decided by the two of them to say, you become the sole executor and you go ahead with the grant. That's also possible.
All right, thank you. Auntie Sue? Okay, Juliana?
Yeah, there's another one from Anne. All our insurance, EPF, and investment have beneficiary names stated. For house property, that's joint names. So if one spouse died, all her assets and property already got beneficiary name status. So why do we still need a will?
Excellent. Thank you for that question. I'm going to have to break it down to different kinds of assets. But specifically for insurance and EPF, if you have nominees mentioned in your insurance and EPF, then your will, or then the insurance and EPF actually falls outside your estate. It becomes a trust. But legal terms aside, what it basically means is this: if you pass away, the nominees can immediately go to the insurance company, don't need grant of probate, can immediately go to the insurance company, can immediately go to EPF and say, this person has passed away, please transfer the monies to me. So quick example, if I name, let's say, my daughter as my nominee in EPF and I pass on, my daughter does not need to apply for a grant of probate or get my executor to apply for a grant of probate. My daughter just has to go to EPF and say, my father has passed away. Here's the death certificate. You can confirm it if you want, but can you please transfer the monies over to me? Once EPF confirms that I have passed on, EPF transfers the money directly to the nominee. That's how it works for insurance and EPF. Investments, I have to see specifically what kind of investments they are. But if they have beneficiary names mentioned there, there is probably an agreement or an understanding that what takes place is that if I do pass on, then the beneficiary may take it specifically. House property though, if it is in joint names, in Malaysia, the joint names carry a certain share each. So it could be 50-50, which is usually the case, or 60-40, 70-30, and so on and so forth. When somebody passes away, the share that the person has in that property does not immediately go to the other joint holder. And so because it is not a survivor takes all kind of scenario, then somebody needs to, that the will is required in order to identify who is going to take that share of the property. So again, for example, if my wife and I own property 50-50, if I pass on my 50% share, I can decide who I want to give it to. I can give it to my daughter, I can give it to my wife, I can give it to my brother, I can give it to anybody else. But if I pass on without a will, I still need to, the court will still need to, sorry, let me rephrase. If I pass on without a will, that share of the property is still in my name. And then someone needs to either apply for a grant of probate or LA, letters of administration, regardless of whether I have a will or not, and then deal with the asset according to either the law or according to the will. So as far as house property is concerned, that's one reason why you need a will. The other one that you may want to just think about as well is joint accounts. So joint bank accounts has a survivor takes all policy, usually. All right. So if I have a joint account with my wife, if I pass on, immediately my wife takes all. In that context, then yes, a will is not necessary. But in house property, for example, where it is what we call co-ownership, not technically the term is not joint ownership, it's called co-ownership. I have 50-50, my 50% is still in my name. When I pass on, that has to be addressed either through my will, or if I have no will, then through the law by a grant of letters of administration.
Thanks, Pastor. Auntie Sue, is there anything you want to raise up? Any?
Yes, somebody asked this question. If I have a good value asset and don't want them to dispose of after my death, is it possible?
If you have a good value asset and you don't want them to dispose it after your death, okay. I'm not quite sure what the good value asset is, but generally when you do a will, you can decide you can tell them basically you don't want it to be disposed of. But if you don't want it to be disposed of, and I presumably mean don't sell it, but if you don't want it to be disposed of, you still have to identify who you want to give it to, or where it goes. All right. It cannot be in your name for perpetuity. It cannot be in your name forever. It has to go to somebody else. If it is in your name forever, at some point, you will end up having complications, or the government of Malaysia may step in. So the question is, what decision do I make as far as that particular asset is concerned? If, for example, a good value asset happens to be your property right in the heart of downtown KL and it's landed, all right, so it's worth a whole lot of money, and you don't want it to be sold off, then what you can do is identify a person that you want to hand it over to own that property, essentially make someone a beneficiary of that property to be dealt with. And you could even potentially make it a condition that I give it to so and so for as long as this person does not sell it within the next 20 years. And that would be your intention. Right now, whether the person eventually does it or not, and who then can fight to prevent that sale from taking place, those are issues that may end up in litigation. But he can express his intention and say, this is the condition. If he still wants to sell it within the next 20 years, then he cannot take the property. That kind of thing. Yeah.
Okay, thank you. All right, Alicia?
I have a question here from Henry Mock. Can you include offshore investment or cryptocurrencies that are not recognized in Malaysia in your will?
Malaysian law, assets in Malaysia, let me rephrase this. Assets in Malaysia will be dealt with in Malaysian law, although you can actually do a will that addresses assets elsewhere. So it will look something like this. If I have offshore investments, and they all are, if you follow the Panama Papers and all the money laundering that was taking place, a lot of people have offshore investments, and I hope that whoever's asking this question, his name is not there. But anyway, if I have assets overseas, basically, if I have assets overseas, I can do one will and cover all these assets. That's not a problem. But when I actually deal with those assets, they will not be dealt with in the Malaysian courts. It will have to go to the court, let's say in New Zealand, for example, and that's one of the things we did. The asset was in New Zealand. We had to go to New Zealand, get a grant of probate there, or resealing, or what we call a resealing of the grant of probate there, so that the executor can under New Zealand jurisdiction, deal with the assets in New Zealand. The same for anywhere else overseas as well. We've done cases where assets are in India, New Zealand, Singapore. Singapore is a common one. And so then in different jurisdictions, in different countries, you will have to get a grant of probate or LA or whatever they call it in their country, specific to their jurisdiction, and then deal with the assets and still follow the will. The other interesting thing that you may want to take note of is this. The way you want to distribute in your will may not apply in that jurisdiction. And if it doesn't apply in that jurisdiction, the jurisdiction will then usually provide by law what happens then. And so I don't speak for other jurisdictions, but there may be situations where, for example, your assets are in maybe a very strong Islamic influenced country, where the rules and the laws are such that they follow Sharia law, for example. And then you say, I want to give this to so and so, and you realize, hey, actually you cannot. Those kind of things. So it applies in those jurisdictions, and those jurisdictions will have alternative provisions for that kind of situation.
Okay, Auntie Sue?
Somebody wants to know, generally, how much does a lawyer charge
for doing a will, or for applying for grant of probate or letters of administration? Was it specific?
Auntie Sue, please.
for writing the will? For writing the will.
Okay. It varies actually. I'm unfortunately to the honor of my profession and the people in the fraternity, I can't give you figures. Different people charge differently, and it also is based on how complex the will is. Obviously, if people specialize in it, then the fees may be higher. I get the question a lot when people say, I just want to do a general will, I just want to do a general will. And then when I look at the terms and what they want to do in their will, I go, actually, auntie, uncle, this one not so general, it's not a one-pager, for example, because people start thinking about, hey, actually, what happens if this, what happens if that, what happens if this, what happens if my executor passes away, what happens if my beneficiary passes away, and then extra clauses come into play, extra alternatives come into play, and then the will doesn't become as general as we initially assumed it would be. So unfortunately, I can't tell you exactly what kind of range we're talking about. But what I would suggest, though, is if you intend to get a lawyer to write a will, by all means, ask around and see someone you can trust and someone who is able to, meet your fee range that you are comfortable with.
Okay, thank you, Pastor. Juliana, anything?
Yeah, there is this Vincent who wants to know, can we choose another executor after naming a trust company to do so?
You can. There are two possibilities. I would suggest the second one, but the first possibility is this: I appoint a trust company, and if the trust company doesn't want to do it, I appoint an alternative executor. That's the first possibility. Now, the reason why I don't suggest that is if the trust company is the only time a trust company will say I don't want to do it is if they're closing down the business. Otherwise, if they want business, they will definitely take it up, all right. So the second possibility is this. The second possibility is to identify the trust company, but set conditions, and then the alternative executor comes in. So, for example, sorry, let me rephrase that. Your first will may identify a trust company. I'm not sure why you would want to appoint a second person, but if later on you've done the trust company already, and the trust company knows you've appointed them, but you want to change to a personal executor, an individual, you just have to update your will. You just say, look, I'm putting a new will, I'm canceling my previous one, I'm revoking the previous one, I appoint this new executor as the individual executor. The one about setting conditions, sorry, let me just scrap that. Let me withdraw that particular statement. So the first one is either you do it as an alternative in the same will, or you update your will and remove the trust company and say, I want to do this with an individual. Yeah.
Thank you. Alicia, I think there's something.
There's one very interesting question. If the estate result is net negative, i.e. liability is higher than asset, would the benefactor inherits the liability? If the benefactor inherits liability, is there a way to overcome in writing of the will?
So the answer to that question is that the beneficiary does not inherit the liability. It's a very basic principle. I think it's partly even biblical as well. You don't pass your liabilities on to the next generation. So what happens now in the case of, let's say I have a house, but my loan is really high, and I don't have the assets, or the value of the house is not going to cover that. The liability remains the liability of the estate, but because it is a net negative, then it's treated as what is called an insolvent estate. And when it is treated as an insolvent estate, then the executor would have to inform the bank, for example, inform the creditor, this is all I have as far as the assets are concerned. This is all the estate has, sorry, not I have. This is all the estate has as far as the assets are concerned. These are all the liabilities as far as the estate is concerned. Now, because we know the assets cannot settle the liabilities, you are going to have to take a haircut of it, or somebody uses that asset, tries and invest it or whatever, but that's based on whether the creditors are agreeable to what you intend to do. Otherwise, the creditors will just have to take a haircut of the liability. But my point is this, it does not go down to the beneficiary. So the beneficiary, let's say my children, let's say I end up having a net negative, my children will not have to bear it. What becomes a slight problem is this. If it is a charge on the house and the kids stay in the house, and the bank says, I want to foreclose the house, that will become a tricky issue. They unfortunately no hard and fast solution, because it's not the fact that the beneficiary has to fork out of their own funds, but the fact that the beneficiaries then don't get a chance to continue staying in the house that they are staying in. And that the law does not provide a technical way out of this immediately. We've got to look at context, we've got to look at possibilities, situations, and perhaps that's an opportunity for the church to come in and go, okay, I think we'll try and help you out here. And give this family a home. Yeah.
Oh, thank you. That's a good one. Auntie Sue, please unmute Auntie Sue.
Okay. There's one question here. Does the beneficiary need to pay stamp duties upon transfer of properties to the beneficiaries when inheriting the property?
Yes, but nominal.
Okay.
So it is not based on the value of the property. The law says that you pay a nominal. If I'm not mistaken, it's either 10 or 20 ringgit. But it is not based on the value of the property.
Okay, thank you. Juliana, ada lagi?
Yeah, there's one from Joe. For insurance and EPF, what happens if the beneficiary stated is different in the will versus the EPF in insurance? Which one takes precedence?
EPF and insurance takes precedence. Like I mentioned just now, if you name a nominee in EPF and insurance, and there's, sorry, let me just clarify that. EPF and insurance, the nominees that you name there are specific people only. It can either only be your, if I remember correctly, it's only either your wife or your children. If you name anybody else, then it has no effect, the will kicks in. But if I name nominees who are, let's say, my wife and my children, specifically for insurance, then it falls outside of the estate. So I can say whatever in my will, the insurance company does not have to follow. It immediately goes to the nominee. The same for EPF as well. Yeah.
Okay, we got a couple more minutes. Alicia, anything else?
There's one more. Also, this guy, I think he has a CPF fund in Singapore. If someone has CPF funds in Singapore, can the executor withdraw the cash after the person died, or should it be withdraw and deposit in Malaysia?
Sorry, what funds is that?
CPF.
CPF fund in Singapore.
Yep.
Singapore CPF. Au Yong, you are mute. Sorry. Wayan, you're mute. Okay.
Yeah. Okay. Yeah. So CPF funds in Singapore, what happens? Now, first of all, if CPF funds in Singapore, I'm not entirely sure what the Singapore law is as far as naming nominees are concerned. Assuming he didn't name a nominee and it goes inside the estate, the executor then has to go to Singapore reseal the grant of probate so that it becomes sealed by the court, the High Court in Singapore. Then he can go to CPF and then take out the money. Now, how he wants the money taken out is up to him lah. You can say, okay, I have this bank account, can you please put inside the bank account? And usually, I wouldn't think that CPF would transfer directly to Malaysia lah. So you transfer to a Singaporean bank account, and then from that bank account, then he can handle it, whether he takes it out in cash or transfers it over on a TT transfer back into Malaysia. That's up to the executor lah.
All right, it's coming up to 12. Can we take one more, two more?
Yeah, one more from internal. Is there a legal time frame? Is there a legal time frame for the executors to execute the will? Is there a legal time frame for the executors to execute the will?
Technically, this is a good question. This is something that we sometimes debate about in court, because we always talk about whether the executor has delayed in his work or not. And it is actually very arguable. The reason why I say is this: there is no specific provision to say that the executor, as far as I remember correctly, that the executor must take up the probate within a year or within 2 years or whatever. But what it does provide is this: once an executor or an administrator has taken up the grant from the court, whether it's a grant of probate or grant of letters of administration, the representative, the executor or administrator, has a 1 year grace period where nobody can file a lawsuit and say you have delayed in your work. And so it gives them this time period for them to start working on things without having this threat of a lawsuit or somebody coming and say, why you delay, why you so slow? And that one the law provides. So we've had situations where people take 2 to 3 years before they take up a grant of probate, or even apply for it. But as far as I remember, there is no particular provision to say that you must do it within a particular time.
Thanks, Wai Nyan. Paul, a lot of questions coming in. It's already 12 o'clock. Okay. I think we have to, sorry, people with questions. We have the recording. Later on, you can just look at the recording. Paul, over to you.
Right. There are a lot of requests for recording, and normally we will do the recording and put it up in our ministry website in SIBKL. So please look out for that recording. You can access it later on. I think Jane, you can put up the. I think it's already there, isn't it? Yeah.
I can put up.
There is a link there, right?
Yeah, I put up the links for all of those who wants extra recording slides. Please join us in our GE News group, and you will receive all the updates in the news group. I have put a link, and I will be constantly posting the link just in case you miss it.
Right. Thank you, Juliana. Right. I think this session will never end if we continue to answer all the questions. And we want to thank Pastor Au Yong for really blessing us with his practical experience, practical advice. I think a lot of us have benefited from it. It clarifies a lot of things. And those of you who have not done the will, I think the message from our pastor is go and do one, right? It will spare us of a lot of pain later on, right? With this, I'd like to thank Pastor. Thank you for blessing us. And well, those of you who are around, just wave to Pastor to give thanks to him. Yeah. Pastor Gilbert, are you around? Would you like to, yeah, Pastor Gilbert, would you like to closing for us?
Yeah, thank you so much, Pastor Brian, for this very fruitful and very informative and also very good advice that it is so apt for our generation, actually. Yeah, I hope all of us have been blessed, and as we look forward to more topics that's very relevant to every one of us. Yeah. So come, let me pray a blessings for everyone. We are so thankful, God, for today. And Lord, thank you for the wisdom and understanding that we needed. And we pray that even as we digest, God, and make, God, our decision on what to do next, we just pray for your continued guidance of wisdom, and also, God, to give us, God, that connection to the right executor or whatever wise that we need. We just pray that, God, that help us, God, to make the right decision. So we thank you once again for all who came in to be benefited of this session. We ask for your blessings, God, to go with us. So may the Lord bless all of you and be gracious to you. And may the Lord radiant smile always shine upon you. And may he turn his face towards you and grant us the peace. In Jesus' name we pray. And everybody say, Amen.
Amen.
We'll see you next month. Yeah, for
Yes, we'll see you in
Christmas celebration.
Right. Remember to join us next month on the 16th of December, SMCC Level 2 Cafeteria. Look forward to see all of you again.